in fact, and then spent all 4 years of their college career making the fourth floor their home. And as an educator, I find it just awe-inspiring that students are willing to give up their Friday afternoons to come to talks like this. A lot of these students have been coming to these talks every week for 4 years, and it's just amazing. And I think they should be acknowledged today for doing that, since this is some of their last colloquia of their undergraduate life. And so if you're a senior, will you raise your hand or stand up to be applauded for your curiosity and imagination? It's just tremendously cool, and I admire all of you, and I'm so deeply, deeply proud of you. Nice job.
Welcome, everybody. It's our last colloquium of the spring semester. As Thomas mentioned, we are so glad to have you all here. It has been a terrific year of Friday afternoon lectures and post-lecture conversations. Today, we're really excited to partner with the Department of History in their Mitchell Lecture Series to bring Dr. Sarah Forsdyke here. I'm going to hand it over to Dr. Jeff Stevens in the Department of History, an expert in ancient history and classical archaeology, to introduce our speaker. Thank you, Dr. Stevens.
Thank you very much, Dr. Conklin. Hopefully everybody can hear me all right, but it's my great pleasure to kind of be able to bring this week's events to a close. This week we have been doing the Mitchell Lecture Series in honor of one of our very revered former members of the history department many, many years ago, Fortis Mitchell, who through his generosity and the generosity of his family was able to fund an endowment that has been able to bring many great scholars to Mizzou over the past recent years. And, I'm very thankful to the Kinder Institute on Constitutional Democracy for helping to co-sponsor this finale event of this week of the Mitchell Lecture Series. And it is my great pleasure today to bring to you our speaker of this week, Professor Sarah Forsdyke. Sarah Forsdyke is the Josiah Ober Collegiate Professor of Ancient History at the University of Michigan, whose scholarship explores the many facets of democracy, slavery, and the law, both ancient and modern. Much of her work begins from the proposition that the ancient Greek past can serve as a valuable resource for examining the issues of today, including how to strengthen our democracy, how to recognize and reduce patterns of discrimination and inequality, and how to reform our criminal justice systems. Her publications include Exile, Ostracism, and Democracy, The Politics of Expulsion in Ancient Greece from Princeton in 2005, Slaves Tell Tales, Politics and Popular Culture in Ancient Greece from Princeton in 2012, and her most recent monograph, Slaves and Slavery in Ancient Greece from Cambridge University Press in 2021. She's written numerous articles on such topics as political protest in pre-modern societies, ancient and modern concepts of the rule of law, and the ways that slaves leverage the law to advance their interests. She is currently working on a project on trial by jury in ancient Greece and contemporary America. A key argument is that trial by jury is essential not just for the equal protection of the law, but also for the engagement of citizens in their democracy. Examination of the ancient Greek jury trial sheds light on these fundamental principles and demonstrates how they are undermined when jury trials are circumvented, as they often are today, and as a result of the plea bargain process. Please join me in welcoming Professor Sarah Forsdyke to this wonderful event.
Thank you. Can everybody hear me? Great. So thank you to Professor Stevens and to the Kinder Center for Constitutional Democracy for inviting me to give this final seminar in this series. It's a great honor and a rare privilege for an ancient historian to address an audience of scholars and students of political science. The opportunity to speak to you today also corresponds with my firm belief that we can learn something important about political systems today by reflecting on the earliest form of democracy from ancient Greece. Now, I don't mean this in the simplistic sense that we should copy elements of ancient direct democracy into our own system, although I will touch on a successful example of such an imitation from my home state of Michigan at the end of this lecture. Rather, when I emphasize the value of studying the ancient past as a means for understanding the present, I'm referring to the idea best encapsulated in a phrase coined by the French structuralist anthropologist Claude Lévi-Strauss that ancient democracy is good to think with. That is, by reflecting on the similarities and differences between ancient and modern democracies, we can best understand the strengths and weaknesses of our present practices. And I hope that I won't disappoint in this ambition in this lecture. So overall, the aim of this seminar series has been to demonstrate that an important but under-recognized feature of ancient Athenian democracy was its invention of a sophisticated system of trial by jury of peers. Indeed, I showed in the first seminar on Tuesday, I guess, that the jury trial was born alongside the democracy itself and was tightly connected with ideals of the equal protection of the law and the exercise of democratic citizenship. In the second seminar, I described the institutional design of the ancient Greek judicial system with its massive juries composed of hundreds, sometimes thousands of ordinary citizens drawn randomly from a representative cross-section of the eligible citizen population. And I argued that this design ensured not only that verdicts were impartial, but that they drew on diverse perspectives to reach just decisions. I further suggested on Thursday, I'm losing track of the days here, that verdicts delivered in public by these massive juries of ordinary citizens enjoyed democratic legitimacy and therefore reinforced citizen faith in the system. My basic argument today is that while the ancient Greek jury trial was much criticized in ancient times and by extension has not had much impact on modern legal practice and theory, it in fact delivered a remarkably high level of justice. Indeed, contrary to modern assumptions, I will suggest that the ancient Athenian jury system held to norms of due process and the rule of law that are comparable to modern ones. So let's begin with some basic facts about the ancient Greek jury trial that have contributed to the modern view that it was a flawed system. In the Athenian judicial system, massive juries of ordinary citizens adjudicated disputes without the assistance of legal experts. Indeed, there were no judges or lawyers in the ancient courtroom, and ancient juries had full power to decide both questions of fact, that is, guilt or innocence, and questions of law. By contrast, in a modern American jury trials, as you all know, there's a division, at least ideally, between the jury that decides guilt and innocence and the judge that decides or interprets the law. The magistrate who presided over an ancient jury trial was an ordinary citizen selected by lot who had no specialized legal expertise. His job was to ensure that basic procedures were followed, namely that each litigant got equal time to present his case and that the votes of the jurors were properly collected and counted. In the ancient Greek jury trial, litigants delivered their own speeches, sometimes with the assistance of a friend or a relative, who provided a supporting speech. If they were wealthy, a litigant could hire a professional speechwriter to compose a speech, but they had to deliver the speech themselves. The absence of legal expertise in the form of judges and lawyers, as well as the full empowerment of the mass of ordinary jurors to interpret the law, has led modern observers to regard the ancient jury trial as a form of mob justice, in which jurors, whipped up into a frenzy by the rhetorical appeals of litigants, decided cases on the basis of their emotions rather than the facts and the laws. And this judgment has been fueled by the views of ancient critics of the Athenian democracy who lambasted the jury courts for delivering what they viewed as flawed verdicts. For example, Aristophanes, in a comic play about the jury courts, from 422 BCE, suggests that litigants flattered juries, cajoled them with humorous stories, and made poignant appeals for pity in order to sway the jurors. This critique is evident in the protagonist's account of his experiences as a juror. And here I quote, "I listened to the defendants making all kinds of arguments with a view to acquittal. For what flattery is not available for the juror to hear? They lament their poverty and they invent troubles to add to those that are real, until by repetition they make their troubles equal to mine. And they tell us stories. Some tell us something funny by Aesop. Others engage in comic abuse of their adversaries so that I laugh and put aside my anger. And if I'm not persuaded by these things, immediately the defendant drags his children up with his hand, both male and female, and I listen as they bleat, ducking their heads together like sheep. They bleat like sheep. So this characterization of the jury is obviously comically exaggerated, but it nevertheless resonates with some key themes of other critics of the Athenian democracy, especially Thucydides and Plato. The historian Thucydides condemned the Athenians for their treatment of two leading politicians in the late 5th century, Pericles and Alcibiades. Thucydides claimed that they were wrongly convicted out of anger and fear, respectively. Plato levied similar criticisms of the Athenian judicial system, in particular through his powerful version of Socrates' speech at his trial. I'm going to suggest that we've been misled by these influential critics of the Athenian democracy. Indeed, it is one of the ironies of Greek history that the views of Athens' critics have survived at the expense of the views of its champions. I suggest that a balanced view of the evidence shows that the Athenians had a firm belief in the rule of law and held to strict norms of due process that enabled most litigants to get a fair trial. Now, this is not to say that the system was perfect. And indeed, we hear of one case in our ancient sources where the norms of due process were egregiously violated under the democracy. However, as we shall see, this case was preserved in our ancient sources primarily as a negative example, and indeed, the Athenians punished the man who advocated this breach of judicial norms. Moreover, this single notorious failure to grant a trial stands in stark contrast to the many extrajudicial punishments of political opponents meted out by the non-democratic regimes that seized power briefly twice at the end of the late 5th century BCE. So the place to start for appreciating the importance of norms of the rule of law and due process in the Athenian jury trial is the juror's oath. Preserved in full in none of our sources, it has been painstakingly reconstructed from numerous allusions and partial citations in surviving law court speeches from the 4th century BCE. This oath was sworn by the 6,000 Athenians who were enrolled to serve as jurors each year. And here are its main clauses. Number 1, I will vote in accordance with the laws. Number 2, I will decide to the best of my judgment in the matters for which there are no laws. 3, I will decide without favor or hostility. 4, I will listen to both the accuser and the defendant equally. 5, I will vote about matters pertaining to the charges. Now, the first clause of the oath is the one that's most frequently cited in our surviving speeches. Indeed, in these speeches, litigants frequently exhort the jurors to obey their oath and vote according to the laws. There is perhaps no better piece of evidence than this first clause of the juror's oath that the Athenians thought the primary role of the law courts was to apply the law. This point is bolstered by numerous other passages in Athenian sources that invoke the rule of law as the primary feature of democracies in contrast to non-democratic regimes. For example, in a law court speech addressing a jury court, the 4th century politician Aeschines drew the following comparison between the Athenian democracy and tyrannical or oligarchical regimes. Recognize, Athenian men, that the laws preserve the bodies and the constitution of those who live in a democracy, whereas distrust and armed force protect tyrants and oligarchies. Oligarchies and citizens of regimes based on inequality must guard against their opponents through the law of force, whereas you, who have a constitution based on equality and the laws, must guard against those who speak and behave contrary to the laws. But how did the jurors determine what the law was without the presence of a judge or a legal expert? In a modern court, the judge instructs the jurors on the law. In the ancient Athenian jury trial, the jurors themselves had to determine what the law was and how it should be applied. It is this feature that has primarily given pause to modern observers. How can ordinary citizens know the law and apply it consistently to diverse cases as is required by standard understandings of the rule of law? The answer to this question is twofold. First, the ordinary Athenian citizens who manned the juries had regular experience both enacting and applying the law, and therefore they were much more knowledgeable about the law than ordinary citizens are today. Secondly, the Athenians well understood that the meaning of the laws is not transparent as applied to particular cases, and that there is always need for interpretation. In light of this fact, the Athenians believed that in a democracy, the people themselves should interpret the laws, not elite legal specialists with their various biases. Let's look at each of these 2 points in turn. So it's important to remember that the Athenians lived in a direct democracy, and they therefore voted directly on the laws themselves in their General Assembly or ecclesia. And here you see an image of the Athenian Assembly with the speaker's platform at the front. The Assembly met regularly 40 times per year and with additional meetings as needed. All adult male citizens, regardless of socioeconomic status, could attend, speak, and vote on the laws and the policies. In the 4th century, a stipend was provided for attendance at the assembly. Perhaps even more significant for their knowledge of the laws was the role of ordinary citizens on the council, or boule, of 500. This body was responsible for formulating and proposing laws and decrees to the assembly to vote on. So here you see a reconstruction of the Athenian council house. It doesn't survive, but you have a better example of a council house surviving from the city-state of Priene. So that you can see it was a rectangular building with rows of seats going upwards and an altar in the middle. As we saw in the second seminar of this series, randomly by lot each year from a representative cross-section of the male citizen population over the age of 30. Since citizens could only serve twice in their lifetimes, and councillors had to be drawn in equal numbers from each of the 10 tribal divisions of the population, it is likely that most citizens served on the council at least once in their lifetimes. Service on the council was intense. The council met every day except on festival days. According to one estimate, this means that they met 275 days of the year. For 1/10 of the year, each tribe's contingent of 50 councillors served as an executive committee of the council and assembly, and 1/3 of these were required to be on duty for 24 hours continuously, taking their meals and staying overnight in a public building, the tholos that was right next to the council house. In addition to the Athenians' direct experience in formulating and voting on the laws in the council and the assembly, in the 4th century, the Athenians developed a new institution and procedure for ratifying new laws that required the further engagement of large numbers of ordinary citizens. Without going into too much detail, and you can see it's very complex, the essential innovation was the creation of a new board of lawgivers, or nomothetai in Greek, whose job was to hear arguments for and against any new law, and to vote whether to ratify or reject the new law. This board of lawgivers was drawn from the 6,000 jurors selected for service each year, and therefore was a randomly selected representative cross-section of the adult male citizens over the age of 30. Boards of nomothetai numbered anywhere from 500 to 1,500 citizens, and sometimes even more. The main goal of this new institution of lawgivers was to ensure that laws passed in the assembly underwent an extra layer of review before being ratified. Some scholars have compared this review to judicial review in the modern American system, except with the crucial difference that the review of legislation was performed by a large group of randomly selected ordinary citizens rather than a small group of legal experts. The important point right now is that the Board of Lawgivers was yet another forum in which large numbers of ordinary citizens gained direct experience with the laws. Finally, in this catalog of Athenians' direct engagement with the laws, we must not overlook the fact that the Athenians regularly served as jurors for an entire year, perhaps as frequently as once every 3 years. Last seminar we talked about this, that 1/3 of the citizens would have served every year. So that means that on average, every citizen would have served for an entire year every 3rd year. And so they gained a great deal of knowledge and experience with applying the laws in the courts themselves. So this brings us to our second point, namely the Athenians' belief that in a democracy, the people themselves should interpret the laws, not elite experts such as judges. At a fundamental level, this belief rested on a profound recognition that the laws do not speak for themselves and therefore always need to be interpreted in relation to particular circumstances. In light of this recognition, the Athenians made a conscious choice to put this act of interpretation in the hands of the mass of ordinary citizens, as opposed to narrower groups of legal specialists who, as we can arguably well see in our own judicial system, are never wholly free of bias. On the one hand, the Athenians' choice drew on their historical experience of the partisan application of the law by elite magistrates in the pre-democratic period, as I discussed in the first seminar. On the other hand, this choice rested on a judgment that the mass of ordinary citizens were best placed to balance the strict letter of the law with a sense of fairness or equity in particular circumstances. It was this combination of the law and equity that the Athenians viewed as necessary for justice to be served. Evidence for these assertions may be found in the juror's oath, supplemented by various discussions in Plato and Aristotle. So let's begin with the second clause of the juror's oath. I will decide to the best of my judgment in matters for which there are no laws. A key question is how this second clause relates to the first one. Does the requirement to decide to the best of one's judgment apply only to situations in which there are no relevant laws, or also to cases in which there were ambiguities, i.e., the need for interpretation in the law, and where strict application of the law could result in injustice or unfairness? Scholars have lined up on either side of this question, although recently there's been more support for the broader interpretation. It is significant, however, that even on the narrower interpretation, the Athenians recognized that it was not always possible to decide according to the laws, and that jurors needed also to rely on their own judgment of what was just in the absence of explicit instruction from the law. Support for the broader interpretation of the clause moreover, can be found in the philosophical texts of Plato and Aristotle, who not only acknowledge the need for the interpretation of the law, but also provide evidence that Athenian jurors aim to strike a balance between the strict application of the law and considerations of fairness or equity. Fascinatingly, although both philosophers strongly supported the ideal of the rule of law, each acknowledged the impossibility of its full realization. For example, in Book 3 of his treatise on politics, Aristotle acknowledges the problem with a strong notion of the rule of law, namely that the laws enunciate only general principles and do not provide directions for dealing with circumstances as they arise. Plato also identified this problem in his dialogue, The Statesman, and I quote, "Legislation can never issue perfect instructions which precisely encompass everyone's best interests and guarantee fair play for everyone at once. People and situations differ, and human affairs are characterized by an almost permanent state of instability. It is therefore impossible to devise, for any given situation, a simple rule that will apply to everyone forever. The law," and this is my favorite part, "the law is like a stubborn and stupid person who refuses to allow the slightest deviation from or questioning of his own rules, even if the situation is in fact changed and it turns out to be better for someone to contravene these rules." I love that. The law is like a stubborn, stupid person. So in this passage, Plato acknowledges not only that the laws do not spell out what to do in every situation, but sometimes it may be better, that is more fair or just, to contravene the laws. Aristotle echoes this view in Book 3 of his Politics, when he observes that the laws should be authoritative in all cases except where they go astray. The verb that Aristotle uses for the idea of going astray has the same root as the noun that he uses for the idea of deviations from good regime types. Aristotle's criterion for distinguishing between good and bad regime types is whether they seek the common good and absolute justice. And therefore, it is clear that Aristotle is envisioning that it is in the circumstance when the law goes astray from these principles, that is, of the common good and absolute justice, that the jurors need to intervene and use their best judgment. In his Nicomachean Ethics, in fact, Aristotle makes the distinction between the law and justice, arguing that justice is a broader category that encompasses not just the letter of the law, but also considerations of fairness or equity. And here I quote, "Both the man who breaks the law and the man who takes more than his share are considered unjust. It is clear then that the just man is both law-abiding and fair. Justice then consists in both that which is lawful and that which is fair, and the unjust is both that which is unlawful and that which is unfair." Similarly, in his treatise on rhetoric, Aristotle observes that the equitable seems to be just, and equity is justice that goes beyond the written law. In another passage in his treatise on rhetoric, Aristotle explicitly connects these theoretical considerations about justice and equity with the second clause of the juror's oath, thereby affirming that this clause is to be interpreted as sanctioning the juror's consideration of equity in determining just outcomes. In this passage, Aristotle is explaining what a litigant's strategy should be in cases in which the law goes against him. "For it is evident that," I'm quoting, "if the written law is counter to our case, we must have recourse to the common law and equity as more in accordance with justice. And we must argue that when the juror takes his oath to decide to the best of his judgment, he means that he will not abide rigorously by the written laws, that equity is ever constant and never changes, even as the common law, which is based on nature, whereas the written laws often vary. This is why Antigone in Sophocles justifies herself for having buried Polynices contrary to the law of Creon, but not contrary to the written law." And he quotes from Sophocles, "For this law is not of now or yesterday, but is eternal." And then he continues in his own voice, "For the judge is like a tester of silver, whose duty is to distinguish between the spurious from genuine justice." So in this passage, Aristotle demonstrates that appeals to broader notions of justice and equity could override the written law, and specifically cites the second clause of the juror's oath in defense of this claim, alongside Sophocles' famous invocation of this principle in his tragic play, Antigone. In sum, although Athens held strongly to the idea that the job of the courts was to apply the law, they also recognized that the laws needed to be interpreted as part of applying them to particular cases. Even more importantly, they believed that a full consideration of justice entailed balancing the strict letter of the law with considerations of fairness or equity in particular cases, and the second clause of the juror's oath specifically sanctioned this approach. Now, it's important to recognize that even modern systems of justice must strike a balance between the legal certainty obtained by the consistent application of the law and the inevitable need to interpret the law in light of broader considerations of fairness and justice. This trade-off is brilliantly captured in a dissent by Richard Posner in a case from the Seventh Circuit Court of Appeals from 1990. And I quote here, "Well, what, if anything, can we judges do about this mess? The answer lies in the shadow of jurisprudential disagreement that is not less important by virtue of it being unavowed by most judges. It is the disagreement between the severely positivistic view that the content of the law is exhausted in clear, explicit, and definite enactments by or under the express delegation from legislatures, and the natural lawyers or legal pragmatists' view that the practice of interpretation and the general terms of the Constitution authorize judges to enrich positive law with the moral values and practical concerns of a civilized society. Neither approach is entirely satisfactory. The first buys political neutrality and a type of objectivity at the price of substantive injustice, while the second buys justice in the individual case at the price of considerable uncertainty and, not infrequently, judicial willfulness. It is no wonder that our legal system oscillates between the two approaches. So my point today is that the Athenians had a sophisticated understanding of this trade-off, and while they tried as far as possible to adhere to the rule of law, as evidenced by the first clause of the juror's oath, they also recognized the claims of equity and substantive justice as evidenced by the second clause of the juror's oath. Yet whereas modern courts, whether they acknowledge it or not, grant to small groups of expert judges the discretionary power to balance the law with considerations of equity, the Athenians put such judgments in the hands of a large representative group of ordinary citizens. If we were to reconstruct the Athenians' logic, we might say that they were aware that expert judges might be the most knowledgeable about the letter of the law, but when it came to the inevitable need to interpret the law in particular circumstances, or when the strict letter of the law needed to be overridden by broader considerations of equity or justice in particular cases, the Athenians believed that for these tasks, a large representative sample of the citizens was the best judge. But the skeptics among you may still object. Couldn't large juries have been easily swayed by powerful rhetorical appeals? Wouldn't such rhetorical appeals persuade large juries of ordinary citizens to decide cases according to their emotions rather than the facts and the laws? Isn't this the picture we get from ancient critics of democracy, such as Aristophanes, Thucydides, Plato, as mentioned at the beginning of this seminar? While it would be foolish to deny that rhetoric played a role in ancient jury trials, a case can be made that the Athenians imposed certain procedural rules designed to curtail its influence and to ensure that the jurors decided on the basis of the facts and the laws. And that's what I'm going to turn to next. And to prove this, we're going to turn back to the juror's oath, and I'm going to skip to the final three clauses. And we can see that these final three clauses aim to ensure procedural justice or due process. In Clause 3, the jurors swear to decide without favor or hostility, in other words, to divest themselves of emotions favoring one side or the other. In Clause 4, the jurors swear to listen impartially to each side, again disavowing personal emotions that might favor one side or the other. And finally, and perhaps most significantly, in the fifth clause, the jurors swear to vote only about matters pertaining to the charges, and thereby implicitly to disregard any extraneous matters, such as rhetorical appeals to pity. Aristotle confirms in the opening of his treatise on rhetoric that the normative ideal was to stick to the facts and that rhetorical appeals to the emotions were considered extraneous. And I quote, and he's criticizing other authors of rhetorical handbooks. He says, "Nowadays, those who write his rhetorical handbooks cover only a small portion of the subject. For proofs are part of the art, the rest are all just supplementary, and they say nothing about enthymemes, which are the body of proof. Instead, they largely busy themselves with things external to the subject. For slander and pity and anger and such emotions of the soul are not intrinsic to the subject, but are directed at the juror. As a result, if it were possible that all trials were conducted as they now are in some cities, especially the well-governed ones, they would have nothing to say because all they're concerned about is rhetorical appeals to pity. For everyone thinks that the laws should require this, and some even adopt the practice and forbid speaking about things external to the subject, as is the practice with the Areopagus. It's a specialized court. And they do so rightly, for it is not right to manipulate the juror by inducing them to feel anger or even pity, or envy or pity. So he's disavowing, arguing that that's not the norm. In this passage, Aristotle affirms the normative ideal which the fifth clause of the juror's oath also articulates, namely that jurors decide cases according to the facts relating to the charges and resist the power of extraneous appeals to the emotions. In support of this final clause of the juror's oath, we know that the litigants themselves were also bound by a law and their own oath to speak only about matters pertaining to the charges. For example, the author of the Constitution of the Athenians reports that when they are judging private cases, they call forth the private cases, 4 in number, 1 from each of the categories prescribed by law, and the litigants swear that they will speak to the issue itself. So they swear on divine punishment that they are not going to stray from the issues. But if the jurors and litigants were bound by oaths to stick to the matters pertaining to the charges, who policed in practice these boundaries during the trial? In a modern trial, this is the job of the presiding judge. In ancient jury trials, the jurors themselves played this role by shouting out in protest if a litigant transgressed the boundaries of what they considered to be relevant to the charges. The evidence for this claim is the numerous occasions in surviving law court speeches where a speaker changes tactic in response to protests by the jurors. For example, in a speech written by Demosthenes, the speaker anticipates the juror's objection when he says, "I would like you to hear, but perhaps you'll think it off point." Apparently, the speaker was right about the juror's disapproval, since a few moments later he says, apparently responding to the juror's protest, "Since you consider this off point, I will let it go." In some cases, the speaker encourages the jurors to protest and prevent his opponent from bringing up irrelevant matters. For example, in one speech, the speaker reminds the jurors of their obligation to decide the case on the basis of matters pertinent to the charges, and encourages the jurors to protest if his opponent brings up irrelevant matters. And he says, quote, "You have sworn to decide the case not on the basis of whatever the defendant thinks right, but on the basis of the matters about which the plaintiff makes his case. And the issues must be made clear in the plaintiff's written complaint. Don't let my opponent ignore these issues and speak about matters unrelated to the charge. Don't you allow it, even if this man is shameless." In this last passage, it is noteworthy that the speaker makes mention of the plaintiff's written complaint, another procedural guarantee of due process. Indeed, a required step in the procedure leading to a jury trial was that a preliminary hearing was held in which the plaintiff presented his charge in writing along with any evidence he might have, for example, witness testimony, contracts, wills, etc. At this preliminary hearing, the defendant is also given the chance to state his case and present any evidence of his own. After the hearing, written copies of the evidence were sealed in a wide-mouthed jar, an ekhinos, and no new evidence could be introduced. As Gerard Tour has shown, this procedure ensured that each side was informed of the arguments and evidence against them and could prepare accordingly. And here you can see the fragments of the lid of a jar on which are written, and you can't really pick it out in this photograph, but they're Greek. You can see some Greek letters here in this transcription, and here's what it says. It's basically listing the contents of the documents in the jar. Of the written copies, the following 4 are inside: oath claiming the opponent's testimony is false from the preliminary hearing, law on the abuse of heiresses, challenge of testimony, and finally, oaths of the litigants, the oaths that they will stick to the matter, the charges, and so forth. So more could be said about norms of due process in democratic Athens. In particular, their rules of evidence forbade hearsay, and procedures were in place to prosecute witnesses who gave false testimony. Most fundamentally, defendants had a right to a jury trial, and the violation of this right was associated with non-democratic regimes such as tyrannies and oligarchies. Even Plato's beloved teacher Socrates was granted a jury trial and took the opportunity to defend himself with vigor. The jury's verdict was close in this case. If we're to believe Plato, the final vote was 280 against Socrates and 220 for Socrates. The one violation of the right to a trial under the democracy was the collective trial of the Argonauti generals in 406 BCE. This case went down in history as a grave violation of the central principle of democratic justice, that each man deserved an individual trial. Notoriously, what happened here is that the generals were given a collective trial. They weren't given independent trials, which was a firm principle of the Athenian democracy. Every man has a right to an individual trial. And the man, this was a notorious breach of due process, and the Athenians were furious at the man who had persuaded them to do that in the assembly, and they punished him extremely severely. In fact, they basically excluded him from their city-state for subsequently. He was no longer welcome. So he was severely punished. So in conclusion, I suggest that the example of the Athenian democracy shows that ordinary citizens are capable of making complex decisions in both the political and judicial realms. The fact that the Athenian democracy was stable for roughly 200 years suggests that the decisions that they made collectively on the council and at the assembly were conducive to the common good, at least for the most part. In the legal sphere, the Athenians' decisions as lawgivers and as jurors were evidently also beneficial on balance, and classical texts attest to the considerable engagement with and pride in their judicial system. Indeed, the Athenians closely associated their democratic government with both the rule of law and the equal protection of the law, as I discussed in the first seminar on Wednesday. Much of the success may be attributed to the Athenian citizens' direct engagement in making and applying the law, and that is the fact that they had a direct, not a representative democracy. The Athenians' greater engagement with lawmaking and law interpreting made them more knowledgeable about the substance of the law and more sophisticated about deciding how to interpret it in particular circumstances than is the typical citizen today. That said, I suggest that the Athenian democracy shows that ordinary citizens can play an important role in ensuring that the law is interpreted impartially. Moreover, the public oversight of justice provided by juries brings democratic legitimacy to judicial decision-making. Such legitimacy is sorely undermined when defendants are denied their constitutional right to a jury trial, as they currently are in 96% of criminal cases. The vast majority of criminal cases today are decided by plea bargain, negotiated behind closed doors and out of public sight. Such a practice denies defendants the opportunity to defend themselves before a representative cross-section of their peers and thus to benefit from the equal protection of the laws. The elision of the jury trial from the vast majority of criminal cases also denies citizens themselves the opportunity to serve and thereby engage directly in decisions about justice in their communities. Service as a juror is one of the few places in our representative democracy that ordinary citizens today can learn about the laws and practice interpreting them in particular cases. In other words, it is one of the few places where citizens engage directly in self-rule. Okay, I'd like to end with another rare example of direct democracy in action today, and this one from my home state of Michigan. In 2018, the citizens of Michigan approved a ballot initiative requiring the state's electoral maps to be redrawn by an independent commission rather than the state legislature. The commission was to be composed of a randomly selected representative cross-section of ordinary citizens. Sound familiar? So to this end, a call was put out for volunteers, and almost 10,000 Michiganders responded. And from this pool of volunteers, 13 citizens were chosen, drawn roughly in equal numbers from Democrats, Republicans, and Independents. To cut a long story short, despite worries that ordinary citizens were not up to the enormously complex issues that were entailed in redrawing the maps, the commission succeeded in redrawing the maps, and they were far fairer than in the previous maps. The maps were accepted and used in the 2022 elections, and they will be used again in 2024. Because of the complexities involved in the commission had access to impartial expert advice from lawyers, academics, and others. But importantly, however, all the decisions that were made in redrawing the maps were in the hands of the citizens, and they succeeded in drawing maps that were fairer than those drawn by the political experts in the state legislature. Thank you, and I look forward to your questions.
Thursday. We will take questions. I'll hand the microphone off to whoever you designate, but I will let you field various questions. So,
Yeah.
Hi, thanks very much. I guess I'm wondering a little bit about the background realities of political life in Athens. And to make the point, I'm thinking about if you were to look at the transcripts of legal proceedings in the Jim Crow South in the United States, what you would see is formal claims to all the basic principles of justice that we would talk about, jury trials, right, fair proceedings, all that stuff. What you wouldn't see is the mob of Klansmen waiting outside of the building to deliver a different kind of justice if the desired outcome wasn't given, right? And that's just a really specific example. You know, it's innumerable, all the kinds of ways in which informal norms, you might say, subverted the formal claims of justice, but you wouldn't get any evidence of that if you were just looking at the formal evidence, right, seeing how it was complied with. So I'm wondering, and forgive me if this, maybe you treat this in your scholarship, I'm not familiar, I'm from a different field.
I have an answer for you.
Okay, but like, what is our sense of those non-formal aspects of justice in the ancient world, and specifically Athens?
Yeah. You're absolutely right that there were two systems of justice, a formal system of justice and an informal customary system of justice. And so there were certain spheres where the Athenians used practices of social shaming that circumvented the jury courts. And those existed all the way through, even under the classical Athenian democracy. Some previous scholarship used to argue that there was an evolution from informal to formal justice system, but they overlap. So, for example, people who were adulterers, they could be prosecuted in court, but they could also be subject to communally sanctioned practices of shaming, riding an adulterer through the town mounted on a donkey backwards. And this actually punishment goes all the way through the medieval period. It starts in ancient Athens. There are some more gruesome things that are slightly obscene to mention that they used to do to adulterers. So there were certain categories where it seems as though they resorted to these informal rituals of social shaming to deal with it. But I don't think that necessarily completely undermines the ideals that they develop and the very strong notion of the rule of law and procedural justice that they develop in the vast majority of offenses would have gone through the formal system. But it's even interesting in the formal system, sometimes you get examples of the informal creeping in. So in the law on the apprehension of a man unjustly as an adulterer, if he turns out to not be an adulterer, he gets free. If he turns out to be an adulterer, you can abuse him in the court. The law actually sanctions the informal shaming practices in the court setting if he proves in the court procedures to be an adulterer. I don't know.
Well, do we have a sense of how close reality came to those aspirations? Because it seems like the aspirations are good.
Yeah.
In the same way that the aspirations of the United States
Right.
constitutional system broadly, I think, is good.
Yeah.
But what we've seen historically is a massive deficit between the two in terms of
Right.
practice.
Well,
so just how reliable is the evidence?
I think it's really indicative that in 406, when they put the general on trial en masse, and they were so ashamed of it, and it really stands out in the sources as something that was an egregious breach of the norms of due process under democracy, something that tyrants do, it's something that oligarchs do. The Athenians suffered two brief interludes of oligarchic rule at the end of the Peloponnesian War. Oligarchs took over and the democracy was overthrown, and there was brutal extrajudicial killings, denial of the right to trial. So the Athenians really the Democrats really prided themselves on granting defendants the right to a trial and due process. So I think that case is the way that our sources point to that case as a notorious example, a lone example, I think is indicative that more or less most cases did go through the courts.
Any other questions?
Hi, can you hear me?
Yep.
All right, well, thank you so much for the talk. My question was about kind of the perspective of the Athenians. I was wondering how uniform were these ideas of the role of a juror in the society, and how did the individuals sort of learn of them? Like, you talked about how a lot of them understood that there was this, prerogative to interpret the laws. Was this like uniformly understood? Was it a cultural idea that this was important? And kind of my question is, I'm thinking of how it could be used today. Like, do we lack a kind of cultural understanding of the role of jurors that they had that we do not?
Yeah. So I don't know if you were at some of the earlier seminars, but I did talk a lot about the comic evidence for the Athenians as being totally obsessed with service as jurors. So in that same play that I quoted in this lecture, Aristophanes' Wafts, there's the whole plot of the play is about the obsession of an Athenian with jury service. Every day he's going to the courts to serve as jurors. And there are a lot of jokes made in comedy about the Athenians' obsession with the law courts. I think I quoted them in one of the other seminars. At one point in a play, a character points to a map of Athens and says, it's a map of Greece, and one character says, well, there's Athens, and the other character says, well, it's not Athens, I can't see any jurors there. So the idea that the Athenians were particularly distinctive and obsessed is the negative term, but very proud and engaged with their judicial system. That was a point of, and I argued this in the first seminar, the idea, it became identified with citizenship. In order to be recognized as a citizen and have equal dignity, you had to play your role in legal decisions as well as in political decisions in the assembly. That became an important part of citizen identity, citizen dignity, that equal capacity to render judgment in a legal or political context. So it was very ingrained in the Athenians. So you asked how widespread it was in the population. Then I think the next question was about the rule of law.
Was that also part of the culture, the idea that they were supposed to interpret the law as well in their role as a juror?
Yeah, and that clause, that first clause, to judge cases according to the law, is what our surviving speakers emphasize all the time, that the primary role of the courts is to decide cases according to the law. And so they're constantly reminded of that, and the fact that clause of the juror's oath is mentioned way more than any other oath suggests that was a really important ideal. And then you had a third part to your question.
I was just wondering about how this connects to modern ideas that jurors have themselves.
Yeah. Well, from what I understand, I've actually never been called for jury service. I have a confession, I'm a Canadian, and I only recently became an American citizen, so I haven't had an opportunity to serve on it. But from what I understand, judges generally think that jurors perform their duty very well. They take it very seriously, and they generally perform well. I know that sensational cases in the newspapers tend to distort our perspective, but on average, apparently jurors take it very seriously and do a good job. And the evidence suggests that people who engage in jury service, there's been various surveys of jurors after the fact, they think it went, in general, again, they think they took it seriously and they really did a good job. But it also, interestingly, they get more engaged civically after jury service because the experience is a positive one generally. It doesn't disillusion people in the system.
I saw over here first, and then I'll have you pass it. I'll pass it back.
To what capacity? Can you hear me?
Sorry, it seems a little.
Just talk
Okay.
about
To what capacity do you think that like a more direct or indirect role did the religious and militarian positions play in this, as they had like a very strong religious belief as well as like a very strong military in most cases? Do you think they played like a direct role, or was it more beliefs that influenced the jurors?
I'm not quite sure exactly what you mean in terms of did religious beliefs influence their decision making?
Like religious figures and people of that religion, did they directly influence any of the jurors, or is there any evidence towards that?
The Athenians took extraordinary pains to make sure that juries were selected randomly. If you'd heard my previous lecture, you would have seen that they have an incredibly complex procedure for allotting citizens randomly to juries. It was very hard to bribe someone or anticipate who's going to be on the jury. As you can see from the jurors' oath, really the jurors were bound to be open-minded when they came in and to listen to both sides impartially. I don't think I can think of examples where a prominent military or political leader influenced a prominent political or military or religious leader would have influenced the outcome. Pericles, probably the most prominent politician and general in Athens. He was elected general repeatedly, 15 years running at the beginning of the Peloponnesian War. The Athenians punished him. They deposed him from office. They fined him for not performing properly in his position of authority. So the Athenians were very concerned to hold their leaders accountable. They had all sorts of procedures for reviewing the performance of their leaders in office. So, and the jury courts played an important role in examining potential office holders before they held office and examining their accounts after to make sure they hadn't been corrupt or embezzled any public funds. The jury courts play that role and hold leaders accountable. So they don't seem to be intimidated at all. They hold in fact, the leaders are a little bit, people like Pericles and Thucydides. Thucydides also got exiled for 20 years for failing to come to the rescue of an Athenian colony in the middle of the Peloponnesian War. He was accused of having not performed his duty up to par. The elite leaders who performed all of these offices often were resentful that they were unfairly punished very frequently. So they really I think the answer to your question is that they really held their leaders to account, and juries were not intimidated to fine or exile, impose pretty serious punishments on prominent individuals.
Thank you.
There was another question in back, so the microphone's moving over.
Yeah, so considering the size of the United States, how do you think that like a board of lawgivers could be implemented in the United States today?
Yeah, and this goes back to my opening that I didn't think that I'm not advocating that we just import Athenian practices to modern day America. Now, obviously, that's impractical. We have a very much larger nation. So that's what I mean by Athenian democracy is good to think with. We can think through, and I think one of the things that this example of the Athenian jury trial does is to remind us why juries and jury trials are important in a democracy, both in terms of having democratic oversight and participation in decisions of justice, but also in the engagement of citizens in democratic self-rule. So what I would say, and we were talking about this with some students at lunch, is that yes, we need to perhaps hold more jury trials, provide a public stipend for jury service. Right now, of course, there is a small fee that you get for serving as a juror, but it should probably be greater. We need to make sure that more criminal defendants have an opportunity to go before a jury rather than have their cases decided behind closed doors through the plea bargaining process, which itself has increased in frequency dramatically over the last decades, and as a result of the sort of tough on crime policies, because defendants are really worried about very severe penalties, so they can be easily sort of persuaded or bullied into accepting a plea deal rather and foregoing their right to a jury trial. And the jury trial is important for the equal protection of the law, but also for citizen engagement in democracy. So I think what I'm trying to do is say that it reminds us why the jury trial is important in a democracy, and that we should perhaps make sure to reinsert it into the criminal justice process to a greater degree than is happening now.
Did you have one? Yeah. Okay, all right. I'll let you know, and then I'll move back forward.
Thank you for this talk. I was particularly fascinated by the juror's oath. I think that was
Yeah.
very interesting to see the communal appreciation, understanding for such a thing. But my question more so has to go to whether there was a societal understanding and consensus on a divine punishment, if someone was not to go along with that oath, and what bigger role religion would play in this understanding that not only your society would indirectly keep you accountable for keeping the juror's oath, but what divine authority would have had a role in the juror's oath as well.
Yeah, people typically swore on penalty of divine punishment, and belief in the gods was and their ability to punish you for infractions of oaths was clearly very strong. On the other hand, part of the procedure of criminal justice in ancient Athens was that each side had to swear that their declaration was true. One side must have been falsely declaring that. But in general, belief in the gods was very, very high, and oaths were taken extremely seriously. You swore an oath on penalty of divine punishment, not only as individuals, but states also swore oaths for interstate treaties and things. So the gods were powerful forces that had to be appeased, and breaking an oath was taken very seriously. So, yeah, and that's one of the reasons why but we still swear oaths today, right? We still think that it's important. But yeah, the juror's oath would have been something that would have been backed by the gods.
I did see a couple hands up over here.
Hi, thanks for the talk. I really liked it a lot.
Thank you.
I was curious about the Athenian critics of trial by jury and democracy more generally. What sort of alternatives did they sort of envision for the Athenian trials? Like, did they want to restrict the jurors to people who have mules, or was it like something kind of, or did they want to have certain types of experts, or what?
Yeah,
what did
generally
they want to do?
expert rule. And so Plato depicts Socrates as going around Athens criticizing the democracy for its reliance on ordinary judgments. The ignorant, and Thucydides says the same, the masses are ignorant. We need to have expert rule. And so the jury trials were one example of allowing ignorant people to make decisions, but also the democracy itself, where all decisions, public policy and laws were made by the ordinary citizens, and they thought that was a foolish point of system. So they wanted narrow oligarchies, basically of aristocrats. They recognized that tyranny was a bad thing, the rule of one person was a bad thing, but narrow oligarchies were probably the best option. And many Greek states were ruled by oligarchies. Athens wasn't the only democracy, but it certainly was the most radical, far-reaching, egalitarian system. Yeah.
So who was actually entitled to these jury trials? Was everybody in Athens was it equally available to every person?
No, and I talked about this last time. The total population of Athens is something like 300,000, and only 30,000 males were citizens of that 300,000. The rest were enslaved people, so a large population of enslaved people, non-citizen residents, so foreigners who had migrated to Athens. Athens was an economic powerhouse, and a lot of people migrated there to do business. The citizens, both male and female citizens, had access to the courts to have their disputes arbitrated, and there seems to have been access to non-citizen residents. They were called medics as well, although medics couldn't serve as jurors and women citizens couldn't serve as jurors. So only adult male citizens above the age of 30 could serve as jurors, but all citizens, male and female, had access to the courts and could, and so did medics, these non-citizen residents. But there's a vast group of enslaved people who have no legal rights.
I think we have time for one or two more.
Hi there, thanks. Two things stand out to me as potential roles for judges in our modern system that I wonder about how it worked in this system without judges. One, you sort of got into in terms of the pre-trial process of admission of evidence.
Yeah.
It seemed like someone objected, or they noted in the shards that you showed that this was dubious evidence, and so I was wondering, is that something that gets hashed out in the pretrial thing, or you just have to make your case on the stand for whether or not your evidence should be accepted? And then the other thing that judges are responsible for is sentencing discretion. So is that something that's just included in the laws, and then the jurors apply the sentencing based on their interpretation of the law, or is that another thing that was sort of subject to much debate and discretion?
Yeah, so I'll take the last question first. There are two types. Sometimes the penalty was specified in the law. The laws were made by the ordinary Athenian citizens, so they decided for impiety, the punishment should be this. For treason, the punishment should be that. In other cases, there was a second phase to the trial where the prosecutor proposed a penalty. If the person was convicted, then the prosecutor proposed a penalty, and the defense proposes a penalty, and the jurors vote which one they should do. And we were talking about this last time with the trial of Socrates, right? He was condemned, and in the second phase of the trial, he says, at least in Plato's version of his speech, he says, I'm a benefactor of the city. I should get free meals in the public town hall for life. and the prosecution says, we want the death penalty. And so he gets the death penalty. And some people think that, if he had just proposed a fine or exile, he would have not been put to death. But that's the most notorious and famous example of that second phase of the trial. But other cases, like theft, there would be a fixed penalty that was related to the size of the theft and that sort of thing. The first question was?
Pre-trial admission of evidence.
Pre-trial admission of evidence, yeah. So we don't really know very much about that preliminary hearing. The person who presides over it is a randomly chosen Athenian citizen with no particular legal expertise, although I've tried to point out in this lecture they have a considerable amount of legal expertise because they are making the laws themselves. They're regularly serving on the jury courts. They're interpreting the laws. But in any case, as an ordinary citizen who hears the evidence on both sides, it gets sealed in the jar. One of the really interesting things is no new evidence can be introduced at the trial, which I think is a really important protection. So they know what the evidence against them is, and they can prepare accordingly. And it seems as though what happened was that that evidence, they don't have nearly as complex rules of evidence, of course, that we have today, but they did have a rule against hearsay evidence. You had to be testifying to something you'd directly seen or heard. And you could be prosecuted if you gave false testimony. We have a number of surviving trials for false testimony. So that was another procedural protection.
So,
just speak really loudly.
okay. So my question was, so by reading Aristotle's Rhetoric, it seems to me that he believed that there is this justice and equity beyond the law. That law is present to only to interpret the larger moralities that are in the humans and in the society. And I was wondering if Aristotle believed in this ideology of that there is innate human morality and justice inside the human beings, and or if that the humans need a guide sort of to introduce them to this larger morality. And in the oath, in the jurors' oath, it offers like a clue, because in this in these rules, the juries are bound to these oaths, and they have to present themselves and to the court a more perspective of the trial and of themselves. So my question is, if the jurors are bound by this oath, then their interpretation and their morals are bound by the law. Then so then they're like so how would you interpret I guess the oath, like if their justice and morality is only bound by the law and the oath that they're presented to, then sometimes they might say, what does it mean to be without favor, or what does it mean to be without hospitality? Like, what does that mean? And if they could interpret the oath differently and based on the morality that are innate in them, and how is that different? How does that function in a way?
Mm-hmm. If I understand correctly, I mean, starting with Aristotle thinks that justice is a broad category that includes both the written letter of the law and a judgment about what is best in what is equitable, what is fair in a given circumstance. And in that case, I was making the case that justice is not equal to the law. Sometimes it can be wrong to apply the law literally because it can be not equitable or fair in a given particular circumstance. And that in those circumstances, the jurors have to use their own judgment. I don't think Aristotle says one way or another whether all human beings have an innate moral sense, but I guess you might say from the juror's oath that the Athenians believe that each Athenian citizen, at least, adult male citizen, is capable of making a judgment about what is best in the circumstances, even without explicit instruction from the law, that it comes from their judgment and a collective judgment on behalf of the community of what is fair in a given circumstance. I'm not sure if that answers your question, but.
I'm more so wondering, I guess, if they're bound by the oath, then if they could have different interpretations, like what does it mean to vote about the matter between the charges, like
Right.
the difference in that, like there could be different interpretations.
Yeah. Yes. So there is some latitude there. Someone might think someone's prior behavior as citizen might be relevant to the decision, or someone might think, no, we have to stick very closely to the actual acts in question that are subject to criminal charges. So there can be latitude, but with such large juries, you're going to get the sort of average view of the Athenian about where the line is to be drawn, rather than the view of a legal expert like a judge. So they're leaving that up to the community to decide what is relevant. And if you look at law court speeches, actually, what you do find is they have a broader notion of what is relevant to a given case than what we would have today. But some people would argue, and I was quoting a legal scholar at Harvard Law School the other day in this regard, that the ancient Athenians perhaps came closer to just outcomes than we do when we stick very closely to the technical aspects of the law. That you can actually, even with a broader contextual understanding of a dispute, you might actually reach a more just solution than in the modernistic, very technical ways that laws are applied. So yes, there would have been a range of different views, but the point for the Athenians, I think, was that with such mass juries, you're going to end up, the extremes are going to be cut off, and there's going to be a middle ground there where everybody agrees that this is relevant, or this is not relevant, or this is just and this is not just.
Well, I think that this is a good place for us to conclude, I guess, this year's Kinder Lecture Series as well as the Fortis Mitchell Lecture Series. So please join me in thanking Professor Sarah Horstock for a wonderful talk.
And we hope you'll join us for our final Pursuit of Happy Hour out in the reception area. Thank you again for coming today. Have a great summer. We'll see you in the fall.